No sound. There you go. I can't unmute you.
How about now? Now?
Oh, good.
Yeah.
So, in case you missed it, I was asking Ileana Rosa what her purpose in life was, and she's like, I don't effing know. It's
too deep of a question for a Friday where I'm trying to disconnect and like be more casual.
Yeah, you and I both had
That's
court
like
today.
an interview type of question. I'm like,
oh, I would never ask that for an interview question. It's like, I don't care what your purpose in life is. Like, what are you going to do for this firm? Let's talk about that. Let's talk about your feel for justice. Let's talk about your, no, never mind. Anyway, so Sarah Boone, she's been pending trial for 4 years now. She's been sitting in a county jail cell for 4 years, awaiting trial on this case. She's burned through 8 different attorneys, all of which she fired unceremoniously, and got her to the point where she has a volunteer 9th attorney.
Volunteer.
He claims that he's not getting paid for it, or that she's gonna pay his normal retainer. But I mean, with what money?
How exactly?
It's suspected that his main motivation is, I'll be the
Fame.
Lead attorney in a high-profile case out of Florida. I mean, it's high profile for all the wrong reasons. It's not like the OJ trial. It's not like a Karen Reed. Nobody is following this because of the skill of the attorneys. That's what I would say. They're following it because it's a train wreck.
Yes.
Sarah Boone is accused and charged with second-degree murder with all the enhancements. The minimum term, if she is sentenced after being found guilty, is going to be 22 and a half years. Maximum is life. And what she's alleged to have done is she was, follow me, I know that you're unfamiliar, but you'll remember, we've talked about this one before. She was playing hide and seek with her boyfriend on a random, I don't know, casual weekend, Sunday night maybe. I forget the specific day.
Do you play hide and seek?
Do you play hide and seek?
I don't with my husband, so it seems to me a strange thing to do.
How much would somebody
adults
have to pay you to play hide and seek?
I mean, with the children, yes, but with a significant other or other adults, that seems strange. But okay.
This is her story.
Boat. Yeah.
There was multiple bottles of wine. She was properly flushed with alcohol. She claims to have been hungover. She claims to have forgotten that the guy was in the suitcase. Never mind, how did he get in the suitcase?
Yes.
Somehow he got in the suitcase. I have to suspect it was voluntarily.
How do you zip a suitcase when you're inside?
Well, I don't think that she'd be able to zip it up if he didn't agree to lay down and.
How is it hide and seek if you know where you're sipping them?
I don't know. I don't know.
Like, it doesn't make sense.
But what if he did zip himself up and she's like, oh, you're in here now. And then she has this light bulb moment. Now he can't get out. He's at my mercy. Now, there was domestic violence allegations going back and forth with these two. They were involved in multiple allegations between the two of them. Her against him against her. They had litigated portions of it. Cops were called multiple times with respect to them. So there was a history of domestic violence, but it wasn't one-sided because he had accused her of stuff too. And you and I have both had cases where both of them just felt comfortable fighting each other and wrestling and throwing stuff and slapping in the face. And there's couples that are like that. This was one of them. So that's the story. Somehow he ends up in the suitcase. And when he is in the suitcase, there's a famous video of her, for all the things you've done to me, this is what happens when you cheat on me. And she just, she's taunting him. You remember that video? I'm going to pull it up just for your edification. And in case any of the few people that have been following this case haven't seen it yet, Sarah Boone suitcase video.
I remember.
As soon as I start playing it, you're going to remember. So this is let me just share my screen real quick. This is the video in question. Make sure that this is up. There we go.
Okay.
That's him in the suitcase right there.
Okay.
Sarah. For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
You.
Sarah.
You.
Sarah.
Stupid.
What would you say her BAC is when you listen to her
Pretty
slurring?
high. Yeah.
Sarah.
That's my name. Don't wear it out.
Sarah. I can't breathe, babe. Seriously.
Yeah, that's when you do when you choke me.
Sarah. 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 Sarah, I can't breathe, babe.
That's on you.
Sarah, I can't breathe.
It's on you.
Sarah.
Real or ransom. Might want to get video for it extra. Because I got this.
Sarah.
Real or ransom.
Sarah. Sarah, I can't breathe, babe.
Oh. That's what I feel like when you ching on me.
Sarah. Please, Sarah.
Yeah. You should probably shut up.
Sarah.
Shh.
Sarah.
So that's the video that was played
That's disturbing.
to her. Yeah, it's very disturbing. That was played back to her during the initial police interrogation. She's going on with the story like, oh, I don't know what happened. We were playing hide and seek. He hid in a suitcase. I forgot he was in there. I went to sleep, and when I woke up, I found him, and he was dead. That was her story.
Okay.
And then the cop's like, okay, you want to walk that back for us? No, that's what happened. I didn't intend to hurt him. She said that like 1,000 times. They played that video for her, and she's like,
Oh, no.
I think she forgot that she made that video. She was obviously over point two.
Yeah, no,
Very
she
clearly
was
over
hammered.
point two. I believe her when she says she was hungover. And I think that she had like this revelations like, holy shit. So we talked about that suppression here, and you're like, suppressing what? Well, they were trying to suppress the interrogation video.
Okay.
They failed. It's coming in. She was there voluntarily. She was properly Mirandized, all of these things. She was, they tried, but it's staying in. So that video is coming in. Just, you heard that's what the jury's going to see. They're going to see that video. They're going to see this guy gasping for air.
Yes.
They're going to see him writhing around in that suitcase.
It looks like even the suitcase was moved like at some point.
Oh, she kicked him down the stairs. Not only did he suffocate, but there was blunt force trauma.
Oh my.
The theory being that at some point they were upstairs, and then she was like kicking him in the suitcase and kicked him down the stairs, and he's tumbling down the stairs. That's how he got the blunt force trauma, and then she's leaving him in there. So if she did all of that, she beat the shit out of that guy and murdered him. So they didn't charge her with first degree murder, but they got her for second degree. And now, let's just say, well, we'll talk about her defenses. So that is this case. That trial was supposed to start on Friday, but obviously the hurricane. So they postponed it until Monday. Jury selection anyway. I imagine that the trial will actually start on Tuesday with opening statements. She burns through her first 8 attorneys. And for various reasons, she was name calling them. She was calling them buffoons. They didn't know what they were doing. They couldn't work with her. She kept on like writing all these letters to the judges about nobody's listening to me. My rights are being violated. She would write these handwritten 60-page letters to the judge. And it's like, what is up with this lady? And so the point where the judge was like, you know what? You have now forfeited your right to counsel. No public defender will be appointed to you. You're done.
Oh, well.
So she was pro se for about a month and a half, couple of months, and it was way over her pay grade. Everything was going way over her head. She didn't know what she was doing. She tried to get the trial dismissed for violations of her rights. It was nuts. So all of these things are going on. Attorney number 9 steps in, takes her up on her offer, and he's like, all right, here we go. Now he's representing her, and he makes his appearance. Now imagine the patience of the judge. She's been on this case for 4 years, right? So now all of a sudden here's dipshit defense attorney number 9. And now he's going to make the claim that, the state is withholding evidence when 8 other attorneys did not make those claims. And he's like, obviously, I'm going to draw the ire of the judge, or at least an eye roll or annoyance or whatever. He asserts this motion that he wants to use the battered spouse syndrome defense, which is basically it's a self-defense motion. The problem with that is, if you claim that as a defense, that it was self-defense, you can never again say that it was an accident, which may have been a saving grace, but probably not the way that it works in Florida. Because like in California, I've seen a lot of attorneys make this mistake, myself included. I was like, how are they going to prove intent? Like, she's just some dumbass lady. She was drunk off her ass. They were playing hide and seek. He accidentally died. I mean, in California, that's not second-degree murder. That's involuntary manslaughter. But in California, you don't have to prove intent. You have to prove depraved conduct, essentially.
Yes.
Dangerous conduct that no reasonable person would do that leads to a death. And to that regard, she's royally effed. Like, there's no defense to that. So I guess you can say, accident or not, you're a dumbass for doing that, and therefore second-degree murder. That works in Florida, even if it doesn't work in other places. And so I guess I could sort of understand.
I can see how that law is necessary in Florida.
I mean, it's a wacky state. What could you say?
I mean, 'cause I think most people, Florida is Florida. Let's just say that.
Erica Pauly says that you missed that she added a flyer inquiring for an attorney in one of her filings. Yeah, well, there was this flyer I was talking about. She's like, are you keen with a sense of or are you bright with a sense of keen or something? Do you have something? It's like this weird 1920s adverts for an attorney to voluntarily take on her case. Then they're asking, hey, why don't you take shit? I'm gonna take on that case. That lady is nuts. I'll tell you why I wouldn't take on that case. Even though she's on attorney number 9, maybe she's even more well-behaved than she's ever been. Could I ask you a question? You don't even practice criminal defense.
No, I used to help some cases that were from other attorneys, but not really like.
Under what scenario would you ever take testimony from your client prior to trial for any reason whatsoever?
In a criminal case? Probably. I can't think.
You wouldn't.
No, like that's one of the biggest rules. I don't practice criminal law, but I know that's like a big no-no.
I don't know practice criminal law, but I know that's a dumbass move.
Yes.
Well, guess what this guy did?
God.
And everyone was like, oh, what a dumbass. Like, why would you ever do that? Because Sarah probably demanded it and would not agree to certain things. Now, look, there's something to be said. Like, look, I'm not putting you on the stand. And so there's no benefit to doing that. Usually in a motion to suppress, your witnesses are the state, law enforcement, because they're the ones that would have violated constitutional protections, leading to a fruit of the poisonous tree, which would have led to suppression of evidence and all that kind of thing. What the defendant has to say is irrelevant because, look, it doesn't matter what their objective or what their subjective understanding was, if they were free to go, if they weren't free to go. If you failed to Mirandize, there's no argument to be made. You didn't give them the proper notice and therefore, things and suppression and all of that, right? If nobody gave you consent, it doesn't matter subjectively what the defendant knew. You didn't have consent to search.
Exactly.
Fourth Amendment. None of that evidence is coming in, right? So I've done probably, I don't know how many suppression motions. Probably less than 50.
Okay.
More than 30. When I was at the DA's office, it's all I used to do. Suppression motions, all they would let me do. The only witnesses you ever saw were police officers.
I mean, it makes sense. Like, it's on them to pretty much prove that they did.
Well, it's on the
Right.
defense to prove the violation, right?
No, of course the violation, but it's on them also, like, to prove they also like follow all of the proper procedures or
Yeah.
due process and all that. So why would you bring like the defendant to testify if
There's no purpose. There's no reason to do that. Suppression is all about criminal procedure.
exactly procedure?
And their investigative techniques and whether or not they followed the proper protocol.
And the only people that need to follow the proper protocol, it's
There's
the state,
no
not the
reason
defendant.
to bring. Yeah,
That's-
and the judge was getting so frustrated, like, "What the fuck? I'm gonna sustain their objections. Why are you asking her this?" And you know, he would even say, like, "What does her subjective viewpoints have to do with any of this?" You know, you just questioned the officers. They straight up said that she was arrested, that she was detained, she wasn't free to go, and all. He was getting really frustrated with them, and people were saying that, "Oh, this guy's such a dumbass." I don't think that he's a bad attorney. I'll tell you that. And we're gonna watch some of the playback of his performance, and you can judge for yourself. I don't think that he's a bad attorney. I think that Sarah demanded to go on the stand, and it was her right. Now, look, let's talk about that for a minute. Let's talk about that. So, like I said, she's facing 22 and a half to life. That is her sentencing exposure. Now, second-degree murder in Florida, it's classified as a first-degree felony. It's punishable according to Level 10 of Florida's Criminal Punishment Code. And if you're convicted, there's a minimum of 16 3/4 years, up to 25 years, based on various enhancements. Her enhancements gets her to 22 years, minimum. Judge told her that. And the judge has the option of putting her in prison for life, putting her on probation for life, imposing additional $10,000 in fines. I don't know why that's a thing in Florida. That's kind of dumb. But she was offered a plea deal for 15 years. She's been in custody for 4. They weren't even saying that 85% of that you're going to do 85% with good time. They were giving the possibility of 65%. If you behave, it's possible that you will only do 65% of that. That takes her down to what, 9 3/4 years, something like that. She's already done 4. That means she would be out in less than 6, 5 3/4 years from today. She will still be a relatively young woman, be able to see her children grow up or whatever. And instead, the bare minimum that they can do if we go to trial now is 22 years, credit for time served. That means 18 years, 65% of that would be what?
Don't make me too bad. Life.
18.5 times 0.65, that means 12 years. So double the sentence. She'll be in her 60s.
And this was offered while
Yesterday, Friday, Thursday, whenever it was.
when
couple
she had
days
the
ago.
new attorney already, or was she in prepare?
No, she had her attorney.
Okay.
And that attorney made her deny that on the record because, look, don't come to me telling me that you weren't aware of the plea deal. I want it on the record that she knows what it is and she's denying it. They got her. The judge even said, look, if you're convicted at trial, the best we could do is 22 years. They're offering 15 with, credits and all of that.
Yes.
What say you to the plea? Reject. And it's like,
Oh my. That's why she has gone through so many attorneys.
stupid ass.
Wow.
She's dumb.
She is.
What can I tell you, man? She's dumb and she's stubborn. That's a bad combo. You know, it's even a worse combo than that. Dumb, stubborn, and
Confident.
irrationally confident
Yes.
in her intellect. She thinks she's smarter than everybody.
I have dealt with many of those, and it's with opposing parties are like that, and also some potential client. When I see the red flags, I'm like, nope,
Yep.
nope.
I sent you one of those the other day.
Thank you.
So, hey, good luck with that one. Good luck. Well, so now we have to do the trial. Where are we at with this? So here's her defense. And there was this very interesting exchange that the judge had with this new attorney, where she's wanting to introduce battered spouse syndrome. The problem with that is, by its nature, that is a self-defense theory of defense. Which means you can't claim accident. You can't claim it was accidental.
And what is the attack that she was defending from? Like,
that's what the judge's question was.
He was in the inside of the luggage, like,
right. And so the only way this theory works, I talked with Brad, friend of the show, Brad, about this. The only way that theory works, because she clearly wasn't being attacked, she wasn't being abused in the moment. You saw the video. That's what the jury's going to see. Is if the sustained abuse over years resulted in subconscious trauma that was released when she hit 0.20 in her blood alcohol. And now here is her abuser. You hear what she's saying. This is what you do when you choke me. This is what you do when you cheat on me and all this stuff. All of this trauma is being released all at once. Now, they're going to need an expert to say that. And I don't think that they have an expert to say that. That was my unqualified attorney possible way to make that fit. I just don't think you're going to get an expert on that short notice, even though they've had 4 years. Maybe if the guy was on the case for 4 years, you could have found somebody to say that, yeah, it was this trauma dump in the moment. The result of the aggregate result of years of abuse that caused her to behave the way that she did, that led to his death. Yeah. It wasn't that she was being abused. It's that the abuse that she had already sustained had so traumatized her mentally that any kind of elevated level of any narcotic, including alcohol, would have resulted in her making poor decisions. And so, to the extent that this was an egregious act against him, as opposed to an accident, she's defended and covered. Now, I'm stretching that way, but it's the only way that I can logically make it work, because she wasn't under attack. So it would have to be, I'm trying to get whatever attacks she's already sustained to fit in this moment. The only way you could do that is, oh, well, the trauma is just being realized from past attacks. Which you're going to need an expert coming to say that, because that's just my own dumbass interpretation of how that might possibly work.
Now, I've seen, like, I don't know why I remember a case or documentary with a similar situation, but the person was not intoxicated. It was like I don't know, she got tired at some point, and then, of course, killed the husband. Yeah. But I don't remember the case, but I don't remember also... I don't recall if, and I don't think that she was intoxicated while she did it. It was just like arranged. Like she just got done with it. The
history of that kind of defense is, look, I've been suffering abuse at his hands for years, and I just got fed up, and one day I just stabbed him to death.
Exactly. When they're sleeping or something like that, yeah.
That would be a pretty good definition of imperfect self-defense, which is not a defense, which means you're guilty. And so it doesn't work. It doesn't work. It's not going to work here. Which is why I would have, look, if you're not going to take this deal, I don't know what more I can do for you. Exactly. They're going to find you guilty. You can't claim it was an accident anymore, dumbass. So this is the history of that defense. It works like 0% of the time. And it only works when you're actually self-defending yourself. Is that a word? Self-defending yourself? Oh.
My God.
Let's listen to this exchange.
Yes, please.
I'm going to go to 104. What we're going to listen to is the defense is amending its notice to rely on the defense of battered spouse syndrome. And then the judge is like, how? She said it was an accident. She's been saying that for 4 years. And then her attorney's like, it's not an accident, Your Honor. She's claiming self-defense. And then the judge is like, okay, I guess.
Now that you make that face, one of my... I guess favorite things to do while waiting for my cases to be called is just watch the judge's face when the other cases are happening, and whenever an attorney makes or a party makes a ridiculous, I don't know, allegation claim, and you see the judge's face like completely change. I just love that. I don't know why.
Reading the judge is like the most fun thing about these trials, especially with this judge. He's really good. I'm going to share my screen with you all, and we're going to get we're going to, you're going to see in real time. The judge is like, what? It's just it's about 7 or 8 minutes of video, but it's worth watching. You're going to learn a lot about how this is going to go. How do I do this, Dominic? I'll present. All right. Here we go.
Far as possible.
That's her attorney.
Insofar as possible. I did the best I could, Judge. In addition, as soon as we started going through the discovery and gathering information about the prior events, the prior arrest of Mr. Torres, the prior prosecutions of Mr. Torres, we immediately amended the notice on September the 15th of intent to rely on the defense of battered spouse. And again, listed as many witnesses as we could based on the good faith belief that we had that corroborated either by witness testimony or physical evidence, photographs, videotapes, medical record, whatever we could find that would corroborate our defense. In addition, we've listed the ex-husband, Brian Boone, and the last paragraph, paragraph 14 says the defendant's investigation of evidence to support the defense of battered women syndrome is ongoing. The defense anticipates additional witnesses, photographs, videotape, medical records, court records, and other evidence gathered from the defendant's phone will be forthcoming. This evidence will be disclosed as it is discovered. Thank you.
Response, sir.
Judge, the state is not surprised by any of the evidence that has been in the discovery for years. I'm not going to belabor the facts in the discovery, but suffice it to say that the decedent and the defendant had a violent relationship, and generally this violence seems to be fueled by alcohol. We're completely aware of all of this domestic violence history, but that does not make a battered spouse syndrome defense any more than being mentally ill without showing more makes for an insanity defense. Their original notice was insufficient, and there's no reason to argue it since they've amended it. So turning to the amended notice, it still does not set forth what they are going to show that shows that she suffered from battered spouse syndrome. Was the decedent isolating her from her family and friends? Was he telling her that if she ever leaves him, he'll kill her? We have these instances of violence between the two of them. And when we get referred to the ex-husband, Brian Boone's deposition and statement, what he reports is that Sarah Boone would attack him, scratch him, punch him, and that she was a habitual alcoholic.
And by the way, he happens to be an unavailable witness, so they could just say that. Hearsay exception, right? Number, what is it, 22?
I don't know.
I don't remember. It's whatever it was.
And he would have to lay hands on her to restrain her. So we are going to potentially dive into all of this information in trial, but there are still the rules of evidence. And the cornerstone for the battered spouse syndrome defense, which is a misnomer under the case law because self-defense is defense, and battered spouse syndrome evidence is relevant to help a jury understand why it's objectively reasonable for a battered spouse to stay in a situation that puts them in fear of continued violence. The state, and wherein our confusion lies, is nowhere in any of the witnesses or any of the discovery that they have listed, exhibits that they don't even have been listed, medical records and so on and so forth. Nowhere does it set forth this cornerstone that is absolutely necessary before we get into any of this battered spouse syndrome evidence, before we get into any potential reputation for violence evidence of the victim, before we get into any potential specific acts of violence by the victim, before we get into the rebuttal evidence that is going to be offered against her for her violent nature and her drinking. The cornerstone is self-defense. Her statement to the police is not one of self-defense, it is one of accident. She repeatedly says there was no violence that day.
So just understand why he's saying that. Because number one, they're trying to eliminate this defense of battered spouse syndrome. everything that she said is based on an accident, and that's why you're going to notice the confusion with the judge. It's like, this can't be an accident and battered spouse syndrome. It's one or the other. And that's why you're going to see like this academic disconnect between him and the defense. That's why prosecution is saying this. But he's also saying is, we're going to have evidence that she was abusing him as well. And so all of this is coming in. If this goes to trial, then as an offer of proof, this is what's going to happen. And so the judge made came up with an artful solution. You can mention battered spouse syndrome in the opening statement, but if you're going to present it at trial, there's going to be other further restrictions. Basically, you got to have an offer of proof that your witness or expert is going to say certain things. That's why a prosecutor is talking about this stuff.
So that is where the state's position is, that their notice is deficient. It only sets forth that there has been violence between the two of them, and it's apparently exclusively alcohol related. But it doesn't go on to say this violence has caused her to suffer from the syndrome. And here's why. She was afraid to go meet with her family. She was afraid to leave. She was any of the things that make up what is.
So he's saying that defense is going to say, well, that's because I don't have all the evidence. 4 years of discovery. Their bill of particulars is incomplete. That's why I keep hearing them say that.
Actually battered spouse syndrome. And moreover, it doesn't set forth the self-defense claim, which is the cornerstone of this. None of this comes in without a claim of self-defense. And so that's in part why we filed our motion in limine with that response, is the court can and should not allow any mention of battered spouse syndrome come in until self-defense has been established at trial. And as far as I can tell, the only person that can set forth a self-defense claim, since it was just her and the decedent in the apartment that night, is her. So she'll need to testify, and then she'll be impeached unless there's a ruling that the statements that she made to the Orange County Sheriff's Office are not only a violation of Miranda, but are involuntary and unavailable for impeachment use. That's what we're hoping to avoid, because we can't unring the bell during trial. If they put on all this testimony and evidence about battered spouse syndrome and about the past violence, and then we introduce evidence about her past violence against him and against Mr. Boone, it's hard to unring that bell. And even though King versus State, a 2000, I forget which year, 19 case allows the state to point out the things that are promised in the defendant's opening statement but then don't come to fruition, that doesn't unring the bell. So that's what we're asking for. We're asking for sufficient notice. The statement of particulars that is required by the rule, where is it setting forth there is a self-defense claim, and then there is going to be this shown beyond just the past violence between the two of them. Thank you.
Judge,
So just to clean that up a little bit, he is basically stating that, look, battered spouse syndrome, we're 4 years in. It's never been alleged this was self-defense. It's always been alleged this was an accident. Matter of fact, she kept on saying over and over, like over 1,000 times, that this was not intentional. It was an accident. We've been operating under the theory, their theory of the defense through 8 attorneys, that this was an accident. Now they're bringing up that this was a battered spouse syndrome, self-defense. What the fuck? It's basically what he's saying.
Yes.
And so now you're going to hear defendants, the defense attorney's response to that.
scheduled to take the deposition of Dr. Harper October 1, so they're going to know fairly quickly what her opinion is.
What's your response to Wagner?
We're going to talk about Wagner, Judge, and I don't want to talk about that in a minute.
By the way, when a judge asks you that, and you better know the answer,
Yes.
because you know that it's a case he's relying on. If you don't know what he's talking about, you're already dead in the water.
But he's bleeding the argument into state's motion to strike the defendant's amended notice. And I would like for Mr. Henderson to respond to what he said about that. But Judge.
Because I agree, there's two different issues here. The first issue is the sufficiency of the notice, and whether the notice is sufficient under the rule. The second issue from the court's perspective, is it applicable? And that's the hang-up that I'm having.
That's not to be decided today. That's not Wagner, whether it's an accident or whether it's battered spouse and there was self-defense. That's not to be addressed today or not to be decided today. That's going to be based on the testimony.
Notice how he's waffling between accident and self-defense. This is going to piss the judge off, and you're going to see his anger in a minute.
from Ms. Boone about what was going on. But I'd like Mr. Henderson, if you don't,
But that's not what Wagner stands for. Wagner didn't allow, Wagner struck after multiple amendments, and the court, and we can take judicial notice of it if you want to, the court has pulled the file from the trial court in Wagner and has looked at the notices that were filed in that case for the battered spouse defense.
Judge,
The
but
issue,
ultimately, the female defendant in that case claimed that the firearm discharged accidentally.
correct.
And the court ruled, hey, you can't have it both ways. It can't be an accident and at the same time be intentional that you committed as self-defense because you're a battered spouse.
I think that's the judge's point, isn't it?
Exactly. Yeah,
Like, what is he talking about?
For a moment, I'm like, well, that argument doesn't help you.
I know, it's like that's what the judge is trying to tell you. Anyway,
Right.
let him continue.
So how is battered, even,
It's premature for them to be arguing the question of intent.
but that's not what Wagner says. What Wagner specifically says, although the trial court found the third legally sufficient, the court granted the state's motion to strike the notice and precluded appellant from presenting the battered spouse syndrome evidence at trial. And the DCA says that the evidence underlying in that case was all accident. Specifically, the located battered spouse syndrome as admissible where the defendant claims accident rather than self-defense.
We're not claiming accident.
Well, then what are you claiming?
Now, this is where he buries the accident argument altogether. This was kind of the crux of the argument.
Self-defense.
But every case that you cite, Medina, Hickman, its progeny, all pertain to some act by the accused. And that battered spouse is an excuse, a justification, an explanation for those actions.
This was your
How
thoughts
is
earlier.
your purported defense applicable legally?
That's the reason we asked for the statement of particulars, Judge, so we could find out exactly what they were claiming that she did, what overt act or what omission. The overt act, was it zipping him into the suitcase?
But
Was
So here's what the judge is trying to get him, and in case you're wondering, because like it might be making sense to you, what the judge needs him to say is, she zipped him in a suitcase and left him in there to suffocate. That was the act. It wasn't an omission, it was an act. Him trying to say it was an omission is leaving the door open, the idea that it was an accident. No, bullshit. So what overt act did she do? Well, she locked him in a suitcase, which caused him to die. If he says that as her attorney, he's digging her grave. You understand? And so, but he has to say that if he really wants to proceed with his battered spouse syndrome defense. That's the catch-22. The truth and the reality of it is this is not a defensible case in Florida. It might be defensible in other states where you don't have to prove intent, but in Florida, it's not defensible. He should have got her to take the deal.
Yeah.
was that the overt act that caused the
But
death?
all of the battered spouse syndrome cases talk about a defensive issue. Not meaning defense, your side of the ledger issue. I mean an action in defense. Wagner fired the gun. It was accidental. Hickman fired a gun. There was an act that was done by the victim or by the defendant in those cases. And battered spouse was used as an explanation for why it is that they did. How is that applicable to the case at
I
bar?
assume they're going to say she overtly zipped him up in the suitcase. I assume they're going to say he was asking to be let out of the suitcase and she refused. She failed in a duty to act. Later on, she went upstairs and fell asleep. So it's either an act or an omission, but they're claiming an act or a series of acts led to the death of Mr. Torres, which they have alleged was directly caused by Sarah Boone's actions or non-actions.
So that's his argument, right? But what he has to say, what the judge wants him to say is, he's saying that they're going to allege those things. Of course they're going to allege those things. This judge knows that. In order for this defense to work, she has to say those things. She has to, because that's the difference between accident and a purposeful act, isn't it? So that is what's going on right here. What do you think of her haircut?
Hickman, the defendant, stabbed the victim to death.
I was trying to see if it was like a bun.
And the
or something.
justification was battered spouse. In Terry, which you provided to the court, Terry v. State, 467 Southern 2nd 761, it was firearm. What's the
Mechanism?
What is it?
They're the only ones that can answer that, Judge. That's why we asked for the statement
I don't
of particulars.
understand that circular logic. And the reason I don't is because it's your defense.
Okay. I'm assuming that they're claiming that she zipped him up in the suitcase against his will, would not let him out of the suitcase, and therefore he suffocated. So the act of zipping him up and then the non-action of not letting him out when he asked to be let out constituted the offense of second-degree murder. That's the only explanation that we can come up with based on the report, based on the evidence we have. But Judge, you remember Marsha Thompson, the Palm Beach County case?
But there was a firearm.
There was a firearm.
She discharged a firearm.
Remember Dr. Brandon said, on the issue of imminent threat, it is in the mind of the battered spouse
But
woman.
right there's the words. Imminent threat.
That's correct.
There was a threat. Now, I don't know all the cases. I don't know the facts and circumstances of that West Palm Beach case. I don't. I know snippets that you provided to me, but I haven't read any opinions on it. I don't know where it is on the DCA or appellate perspective, and trial court findings are not binding on another trial court. I mean, the case law is very, very clear on that.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video.
In the time leading up to the 2-minute video, he was in the suitcase, dumbass.
I know.
What are you talking about? All right. That was a stupid thing that he said. I'm going to let that one go for purposes of this video.
The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
Florida, the appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I
In
just
4
mentioned
years.
it a while ago.
The word self-defense never came out of your mouth.
Judge,
Words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The words self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Damn. What are you
all
going
he
to do? Now what?
Oh my
Now what?
All this.
Oh. Hey, you want to take this case to be famous, Ileana? What do you
No,
think?
thank you. Famous for the wrong reasons.
Oh, look at the judge's face, man. He's like, you are, what are we doing? What are we doing? 4 years, now you're saying it's self-defense. Oh, the judge is so pissed.
Okay. Right.
Not accident, as they want to allege.
Okay. Does your compatriot want to provide response further? Okay.
All right, so that's the gist of that. I'm not going to get it further because it's like a 2-hour hearing. But what he's just done is wiped out any possibility that she can argue as she wanted to argue at the beginning. This was not intentional. I didn't mean for this to happen. It was an accident. She can never again claim that if they want to continue with this defense of a battered spouse syndrome. Over. I guess my question to you would be, which do you think you have a better chance of prevailing on? Accidents?
Accident.
But intent is not a thing in Florida. It doesn't matter if it was an accident. It's depraved human activity that is the standard.
Well, I don't think.
So knowing that, maybe is battered spouse syndrome the best that she can do?
I don't see it. Like,
Are you trying to say that she should have took the plea deal?
oh yes.
Okay.
100%.
All right. I would have told her that, Sarah, you are an effing dumbass if you don't take this plea deal. You're not going to win all this defense. It's ludicrous. It is absolutely retarded what you're trying to do. I have to stretch battered spouse syndrome so far to find a singular expert witness to testify that could even possibly be a thing is a stretch. And I'm certain they're going to have like a dozen others that are going to disagree. And a jury's going to have to listen to all that. You're going to get convicted. And then, I don't know, you've pissed off this judge a lot for over the course of 4 years. You think you're going to get the minimum? Maybe it's something like 30 years and possibility of parole. I don't know. But the sentencing guidelines are 22 and a half to life. That's it, man. Or you could be out by 2030. What do you want to do? What do you want to do? You hired me for a reason, and I'm telling you, they're going to find your ass guilty. There's not a chance. Look, man, this is why she has 8 attorneys. So God bless this guy. I don't think that he's a bad attorney. I just think that he's probably made a calculated decision that, look, it doesn't matter if it's an accident. They're still going to find her guilty on second degree. The best that she can do is battered spouse. He's not the only one that's had that opinion. A lot of people have been saying that. A lot of the coverage in this case has been centered around the possibility of battered spouse syndrome defense. The problem is you have to stretch it so far. And in doing that, you have to admit it wasn't an accident, that it was a purposeful act. And when you do that, then come on, man, what are we doing? What are we doing? And then they offer, oh, Jesus, she is so screwed. Look, the trial's going to be entertaining, but I am not.
Yeah.
I'm not. If this
Especially
was
if she testifies, like I
she's already testified. Do
oh
you want to
yeah,
hear?
you told me. Yes, I want to hear.
Okay. And she testified in such a way that she screwed herself.
Oh my no.
I mean, not that it matters because she can no longer claim accident, but she just, I mean, she did it to herself. You'll see. So at the suppression hearing, let me just get into the video. I'm going to get into all of the objections. I think that we're like right here. So this is her testifying on the stand, and you're going to see the judge just get so pissed. What are we asking her about this? Who effing cares what her subjective opinion was? The issue is suppression. What are we doing? And I heard a lot of people say, oh, well, the attorney doesn't know what he's doing. I promise you, 99% positive that Sarah Boone demanded to testify because she thought, oh, I'm just going to tell my story. Then everybody will understand and they'll just dismiss my case. And I'm sure he told her that's not how it works.
Yes.
That's not what we're doing today. It's the stupidest thing you do to try to testify right now. Anyway, she wanted her day in court, even though she has a trial coming up on Monday. But let's just see how it went. Am I sharing my screen? No, I got to share it, don't I? Here it is. So she takes a stand, and this is what happened.
That we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home, I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge. Move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation.
All right. So if you're, my biggest criticism of this guy is he doesn't get to the point. There's no need for preliminary questions. Everybody realizes what happened. He should have probably just started with the interrogation. All right. So on the day of,
Yeah.
you were asked to come down to the police department and you spoke to the detectives. Do you believe, is it your understanding that you were there to retrieve a phone? But the second that you get there, what happened? Well, they started asking me questions. At what point did they Mirandize you? Because that would have been a viable.
Yeah,
I don't know. It would have been. Did they ever tell you to get an attorney? Or they had opportunity to have an attorney? No. Okay. Well, then you were coerced into making statements. Blah blah blah. Now, I don't even think that's the case with her, but that's usually how suppression hearings go. You
but
get to
I
the
don't
meat
know.
of it.
Exactly. I'm hearing this. I'm like, why?
You
are
don't
we-
recount a timeline of the whole thing. That's for trial. This is when you were at the police station, what happened? You claim you were coerced. So how were you coerced? That's what the judge wants to know. And this guy is like fluffing him with this timeline. So the judge is like, could you just get to the point?
And the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it. Objection sustained and it's stricken.
When you hear an attorney say something like this, Your Honor, I know, she's the one that volunteered. I told her not to do it. That's basically what he's trying to tell the judge right now.
Did you speak to the deputy about what had happened?
Yes,
Okay. And then, were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Hopesall.
How did you unlock it?
She handed it to me, and I unlocked it.
How do you unlock your phone?
It was with a passcode.
So if you're trying to suppress phone videos like they're trying to do, she just testified that she unlocked the phone voluntarily. What are we doing?
Yeah.
That's like, oh yeah, they found drugs in your car. Well, did you let them search it? Yes. Okay. So then they had consent? Yeah. then why are you bringing this motion? What are we doing?
Yeah.
It's so bad.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Copesel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
All right.
I think the prosecution, because all those questions are really objectionable. Like, what are we doing? Like, he's letting it go because he's been objecting a lot. He's just trying to let him get it out. But at some point, this guy has to get to the point, and he's struggling to find one.
I mean, I haven't read the motion, but I'm still confused. Like, what's the reason?
Well, the theory is she was coerced into giving access to the phone, and coerced into giving certain statements at the station because she wasn't properly Mirandized.
But
She was
she
there
just
under false
said-
pretenses and whatnot. But she just said
She
exactly.
was
Said she unlocked the phone, you know.
she was giving her Miranda rights.
Yeah, she said all of that. And so, like, what are we doing?
Nobody told her she was a suspect, but I mean, Miranda rights kind of tell you you're a suspect. So
I mean, you don't have to tell them that she's like the
Exactly.
primary suspect, but they could give you your rights even if you're not a suspect. You know, it's irrelevant.
After they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on?
And by the way, they already testified that, yeah, she was detained. She was not free to go. So the judge, you're going to hear him say, they already admitted it. So what are you asking her these questions for?
On the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove.
Okay. What was the reason that you wanted to stay over there the night?
Because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copesel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized,
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Copesel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything, or if I just wanted to talk to her about something regarding the case, for me to call her. So I took that to heart, and
She said, do you understand what I've just read to you? And you agreed that you had.
yes,
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
By the way, they don't have to ask you.
Yeah. I
If
was
they
gonna
ask
say-
you a question, you answer it.
Exactly.
Then, I mean, if you were given your rights, you know you don't have to talk, then they don't have to like explicitly ask you that way. And so it's kind of it's irrelevant. The judge is looking at him like he's fumbling around his papers. Oh, that's
The
such
way
a bad
that she
timing.
acted.
By the way, isn't that the worst feeling? Like you have something, your papers are out of order, like
Yes.
shit. And then okay, let's just everybody like hold while I like fumble through my unorganized
And it
stack
makes
of
you
papers.
more nervous. And then, of course, you can't find it because you're more nervous. Yeah, it's the worst. But it happens.
The only times that ever when that happens to me, you know what, Your Honor, could we just take a 15? I got restroom break, whatever. But yeah, it's the worst feeling. And then when the judge is looking at you like that, it's like, oh.
The things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Who cares?
Sustained.
She was in custody.
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
Okay, but she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space. She was.
That all goes to
she was
whether or
being
not-
Let me finish. She was being questioned by two lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
I'll just tell you this, as an attorney that has been in that situation before, when you make your best argument and the judge is like, so effing what?
Yeah.
What does it have to do with the law? Because, Your Honor, just her subjective, she didn't know. You start searching for words.
What I see from here is that he's trying to make a defense out of his client being dumb and not understanding that she was given all of the warnings and all of her rights. She didn't understand them. She still opened her mouth, and he's trying to make a defense out of that. Like, my client is stupid and didn't, although it was done properly and she should have understood, she didn't. But
Yeah, but that's not ever a defense unless you're like a minor or like mentally infirm or something like that.
You're just dumb.
That's not, if you're dumb, hey, sorry, man. You should have paid attention in school. Or I don't know what to tell you, but like he's saying, what does her subjective understanding of anything matter?
cares?
The question is whether or not they
did it.
properly follow the protocol, which they did. He's even saying, look, they already conceded everything you're trying to get out of her. So what are we doing? And then he's like fumbling. I feel for him
Yes.
because I've been there before. I don't know. It always sucks when the judge is like looking at you like you made your best. You thought you made the big point. And the judge is like, so?
I know.
So, well, Your Honor, I have nothing else. I'll tell you what, why don't we just put this over for 6 weeks so I could brief the issue? He's like, no, the hearing is today, dumbass.
I
And
had
so,
a similar situation like that yesterday, but then at the end, the judge kind of turned around because the other party was just a dumbass, and she's like, you know what? Let's just put this over. I'm like, yes, yes. Oh my goodness!
it's like these are the things that nightmares are made of.
Yes.
If you're an attorney.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation.
Okay.
That, I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not,
What's the subjectivity matter?
Excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
I believe it's relevant. Like, this is all I have.
All right.
Why? I don't know, but it is.
Long story short, they denied his motion.
I mean, I can.
Excuse me.
I can tell.
I'm going to cut that off right here. What do you think? That's her attorney.
I mean, he's trying, but
Would you make any evaluations of his skill as an attorney based on the circumstances and what you've just seen?
I mean,
I don't think he's a bad attorney.
exactly. I don't think he's bad. He's doing what he can with the facts that he has.
shitty
He's
case, man.
stretching. He's stretching everything he has, but
Yeah,
it's the law is not on her side.
he's tried his best. It's just not working out. I mean, what could you say, man? I think Sarah is still largely calling the shots in this,
Yes,
which
yes.
is a mistake.
Mhm.
It's just such a bad move that she did not accept that plea deal. I don't see any scenario where she's acquitted
Mhm.
of anything in this case.
Mhm.
What would you say to a hung jury though? What if the jury hangs
Mhm.
and it's like, okay, well, we're going to retry her then. That means she's going to be in there for another maybe year or two to, I guess, try again. And she's not getting out. They're going to recharge her.
Mhm.
And so, gosh, this could... Look, man, a trial begins on Monday. It's going to be I'm going to be... I don't know if I'm going to be live streaming the trial, but I'm certainly going to be doing daily coverage of this one because it's a fun one. Myself, there's a number of other attorneys that are doing it. But
I want to watch it, but I don't know if I'm gonna have time.
I'm going to have to do it after hours. It's just going to be, we're going to replay day 1 of trial, day 2 of trial, and then I'll just offer my commentary and thoughts. I feel for the attorney, but I don't. Nobody told him to do this. Like, he was under no obligation.
He was not appointed. He just chose to be there.
I'll just tell you what, if I wanted my big moment in the sun to take the high profile case, I
This
will not
wouldn't be it.
volunteer for this one. For a losing case, he looks like a dumbass. Even if he's not a bad attorney, he's giving off, he's making a bad impression. Is it a career killer? I don't think it's a career killer, but it's not a good look, man.
It's not a good look, and he's gonna be spending all this time and effort for pretty much nothing.
Robert, if they do delay the trial on Monday, I feel like it's going to be weather related. I don't know what the situation in Florida is right now with respect to the hurricane.
And the
But-
hurricane already passed.
Yeah, I could tell you that this judge is not
Where
granting
in Florida is this trial at?
a Sacola or something like that.
Sacola?
I forget. I forget the exact location. Dominic, do you know?
No.
No,
know
I know the Milton, the hurricane already passed. I know it made a little bit of
But I mean, like structural
Damage.
damage and like some people are without power. I've
some,
heard.
yeah,
Orlando.
Orlando.
Yeah. I'll just tell you this: this judge is not continuing the trial for any
I don't
reason.
think so.
This attorney, this new defense attorney,
Mhm.
when he jumped on the case, thought that this attorney was the judge was going to grant him a continuance. Like, no, No, this is a public case. He knew this was going to happen. I'm not granting continuance. 9 attorneys in. And then he gives this press conference. Oh, I really thought the judge was going to continue it. Now I don't have any time to do anything. It's like, that's your dumbass fault.
Yes.
Like, you knew that going in. You could have like reviewed the past hearings and heard the judge say that multiple times. So I feel for him, but I don't. I'm just saying, I don't think that he's a bad attorney. I just think he's got a shitty case. What are you going to do with this, man? It would have been a lot more entertaining for her to represent herself.
Yeah.
Also, the correct move was to take that plea deal.
Oh,
That would have been the
no,
move.
of course.
Now,
Now that she's in that position,
I don't know,
my
man.
goodness,
If you were in her position, what would you do?
I would have taken the plea.
Obviously. I mean, why am I asking a sensible person?
That's the thing. I mean, if you put like the chances of getting acquitted with her defenses
Yeah.
and like
It's exactly the evaluation you didn't make.
yeah, the balance, and it's like, come on, like
All right, you have this in hand. You'll be out in 5 3/4 years. Or you have a 1% chance of making this battered spouse syndrome work, this theory of defense.
for 0 time.
And if you lose, 99% chance you're going to lose, well, you're doing minimum 22 years minus 4.
It doesn't make sense. But also what she did doesn't make sense, so
It seems like an easy decision. You know what I mean? There's no getting out of this is the point. You're, by virtue of taking this defense, there is no scenario now where you could claim accident and expect anything to happen. It's over. It's over. And even so, I'm not even sure it would have mattered, which is why they're going with battered spouse syndrome. Accident just doesn't, intent doesn't matter in this case. So there we are, man. Eva trial, Sarah Boone. It's going to be a crazy, entertaining trial. I, for one, am here for it. I'm going to be either replaying the highlights or replaying the days of. We'll just see. I'm going to have daily coverage of this one. I've never done that for a trial, but I'm going to try. Now I got my home studio set up at the house. I tried a test run with Dominic. We did a sports show. And
sports show?
He wanted to talk about sports.
okay.
It's like, all right, we'll do sports. I said, what do you know about sports? The Dodgers.
Look at his jersey right now.
Baseball, not just the Dodgers.
Yeah, it's like, if we're gonna do a sports show,
Dodgers.
like what, I mean, the full breadth. We test drove it. We test drove it. What we're
I didn't see
hopefully
it.
gonna
Like
do.
the new. Let me see the arms, like the New Jersey.
Oh, it's-
no,
it's 2020.
Yeah, it's 2020. He's got his game jersey on because today's game 5 for the Dodgers.
Okay.
And, he's got the Corey Seager jersey on. Maybe that'll transfer to Gavin Lux or somebody. I don't know.
My other husband is in the team.
What do you mean, your other husband?
I have a second husband. My first husband knows about him.
Oh, well, good for him. Maybe we should do a flat on that one. Family Law After Dark.
Yeah.
I'm just kidding. I got a other husband. I don't have another husband.
Another wife.
I have another wife too.
Oh my.
All right, folks. We're gonna wrap this up and we're gonna go do flat. We're gonna take about a 5-minute break. I'm gonna get in my other remote guests. I have Ileana in the studio. We're gonna bring in Jocelyn, maybe I'll invite Melissa too. I forgot to invite her. She could join remote if she wants to. Bruce and Brad are gonna be in there. Lauren dipped out again because of she has to go adult. So we'll see y'all then. Hey, Dominic, could you drop the link to the FLAD in the comments? I'll see you all over there. If you have any issues, just go to my channel. You'll see the FLAD as an upcoming stream. Did you reset it to 12:30 or no?
No, I set it to 12.
Damn you. Okay, well, it's going to start around 12:32. Let's just say that.
I just posted the link right now.
All right, cool. Love you, folks. We will see you guys next week. And be safe out there. Bye-bye.
Bye bye.